Hello and welcome to the Rogers Brief for June 15th, 2024. I'm Adam Rogers. Thank you for watching and thank you for listening. I'm going to be covering some stories this week, both on the national stage and some cases out of Nova Scotia that have made the news, and I think you'll find interesting. A couple of the national stories I'll be following or talking about today. One is this issue of whether we have members of Parliament, potentially senators, who have committed treasonous acts by cooperating with foreign governments in efforts to interfere with our democratic processes. Second thing being the Online Harms Act, this new piece of legislation that the government is bringing in to deal with issues of online activity. They finally issued a charter statement, which is the statement that the government is obligated to make every time they introduce legislation, to say why, in their view at least, the legislation is compliant with our charter rights. So they've released that finally. It took a couple of months longer than most people would have expected. Certainly legal experts and people following these kinds of things have been commenting and waiting for this charter statement to be issued. So there it is, and I'll talk about that. Case out of the Supreme Court of Canada. I guess this is a little more than a week ago, but I didn't have an episode last week, so I'll talk about it now, which is about secret trials. And this was an issue out of Quebec. Quebec Court of Appeal was critical of a trial level judge who held a trial entirely in camera, that is, without it being recorded, nothing published about it. And so the Supreme Court of Canada was issued a statement or issued a decision on this, and were critical of the Quebec Court of Appeal terminology in calling it a secret trial. They say that doesn't exist in Canada. I'll talk a little bit about that. And then I'm going to turn to some Nova Scotia situations and news stories, some cases. One is about it's a Jordan decision, Jordan timeframe question about how many cases in Nova Scotia are at risk of being dismissed just because they're running out of time. As you know, the Supreme Court of Canada a few years ago issued a decision called Jordan, where they said that if it's at provincial court level, a trial has to be done within 18 months. If it's at the Supreme Court level, within 30. And so the Justice Minister, Barbara Adams, last week said that there are 1,200 cases in Nova Scotia that are at risk of being dismissed simply because the court system has been too slow to address them, or they've run out of time. It's made the news after the case of Jeremy McKenzie was dropped. It was stayed by a judge, affirmed that affirmed an appeal, not yet anyway, and may not go to appeal. This involved a protest at Dr. Strang's residence, Dr. Robert Strang, Chief Officer of Public Health. Not unrelated to that is Judge Rickola Brinton's appeal of her complaint, her judicial complaint. So I'll talk about that a little bit. And then switching gears a little bit, there was a decision from Chief Judge of the Provincial Court, Perry Borden, on a sentencing hearing dealing with the impact of race and cultural assessment reports. These assessment reports are becoming more common, and Judge Borden used that decision to, in the course of sentencing a youthful offender who was 18, so an adult, but youthful, on a gun and cocaine charge. So we'll talk about that. And then there was a decision out of the Supreme Court this week on the Preston by-election. This was last summer when Twyla Gross was elected, and there was some issues during the campaign of signage put up by the Liberal candidate, Carlos Simmons, and the Chief Electoral Officer ordered that those signs be taken down, announced that there was a police investigation into it, and so the Liberal Party brought a complaint looking for declaratory relief against the Chief Electoral Officer, saying that that was an improper use of the Chief Electoral Officer's authority in that case. Justice Arnold agreed with them. I'll talk about that and why. And finally, I'm going to end off talking about a decision of Judge Vanderhoek, the Associate Chief Judge of the Provincial Court, on these pot shops, these cannabis dispensaries that are popping up, proliferating, I would say, on Mi'kmaq reserves around Nova Scotia. There was 3 shops in question that were raided, 2 in Millbrook, 1 in Cole Harbour. And so we'll talk about that case, the outcome of that. The owners challenged it based on their constitutional right, treaty right that they were trying to assert, and Judge Vanderhoek made extensive comment on that, and so I'll talk about that and what it might mean for these shops, which seem to be pretty common sights if you pass through reserve territory or go by the highway in Millbrook. You'll see them quite prominently advertising their products. All right, so we'll come back around to all that. I'm going to start with the the National Security and Intelligence Committee report of Parliamentarians. So this was the report that said that some members of Parliament are potentially members of the Senate are witting or semi-witting agents or participants in electoral interference. Primarily, it seems coming from the government of China and India is where this seems to be originating. And it's not clear what exactly the circumstances might be where these members of Parliament have allegedly been participating and cooperating. The report is a secret report, and the members of this committee of parliamentarians, they're issued top secret clearance, but it also, so they can access this intelligence and these reports, but then it also means that they're bound to secrecy, not to reveal more than what is in the report. So it puts everybody in an awkward position. Most of the party leaders have access to these reports, but again, they are restricted from speaking about what's actually in them. We've heard some, comments from Jagmeet Singh and Elizabeth May as to what they think should be done or what's in the reports. The Prime Minister has sort of subtly undermined what's in the reports and the intelligence. It seems to me, just based on the process that's in place and the 30,000 documents apparently that were reviewed by the committee and the parliamentarians, that the conclusions are probably safe to rely upon. But who are these people? That's the big question. Should the names be revealed? They're not in the report. Some have suggested, and Minister Dominic LeBlanc, Public Safety Minister, says he cannot release those names, and says it would be dangerous to release them without context. So, and others have suggested, well, let the party leaders see the names and then they can decide what to do about members of their own caucus. But, in that case, if all of a sudden a party leader kicks somebody out of caucus, we're going to know that they've been named. And so that to me seems maybe more problematic. I don't understand what Minister LeBlanc is suggesting about releasing names without context. To me, if you just release the names with context, if somebody is, had a conversation with, an ambassador or somebody in the ambassador's office who might have been, an agent or something from a foreign government, had a conversation at an event or something minor of that nature, well, we can assess that and maybe not think much less of the person or whatever. But if somebody's like going to meetings and traveling abroad and providing documents and reports, such as, to the extent that members of Parliament actually have access to secret reports, which is an open question in itself. Well, that's a different context, and we'll assess that person differently. So I think the only thing to do is to bring this to light. Now, one thing the government, or that Parliament has done, it wasn't really government directed, which is to recommend passing these names or the report on to the ongoing foreign interference inquiry that is led by Justice Marie-Claude Hogue, respected Justice of the Quebec Supreme Court, who is presiding over that inquiry, to have her assess the situation and figure out what should be published. Seems like a good middle ground, but that report is not going to be published until the fall at the earliest, just because now they're giving her more work to do. I wouldn't be surprised if that report gets delayed by a few months, also maybe into 2025. So it's not very satisfactory to have to wait that long. Meanwhile, these potentially treasonous MPs are sitting in Parliament and accessing more and more information. So that seems like something that warrants a little more urgency. All right, next national story, the Online Harms Act. So there was a big article in The Atlantic, a big American magazine, and the article was entitled "Canada's Extremist Attack on Free Speech." It was making the rounds last week, and the opening paragraph of the article in The Atlantic talks about how George Orwell introduced the idea of thought crime, and Philip K. Dick in the Minority Report book, which was made into a movie with Tom Cruise, introduced the concept of pre-crime. And here is the Canadian government, by this author's interpretation, combining both of those. And so there is some good provisions in here about protecting children from online harm and non-consensual image sharing, but the good parts sort of try to hide the bad parts. This was the point of the Atlantic article. Hate speech prohibitions advance what they call peace bonds. Now, you can get a peace bond against somebody who threatens you with harm. What the Online Harms Act would do with physical harm or harm to your property, what the Online Harms Act would do is extend that into somebody who is about to say something hateful. And so it all seemed very unwieldy, I guess. Difficult to predict how exactly those things would be interpreted. And so I was very curious to see what the government was going to say in their charter statement to justify it. So one of the big issues is that if you commit a crime and it is determined that it's motivated by hate, then you're liable to life in prison. So that seemed outlandish, right? To have at risk life in prison. What the charter statement says is, well, just because the maximum is life in prison, there's no minimum, and so it'll be up to judges to use their discretion to find an appropriate range of penalties. Well, having been in court and listened to judges make decisions on sentencing, I can tell you that when they make decisions on sentencing, they will talk about, okay, well, this crime has a maximum sentence of 10 years, and so that means that means something. This crime has a sentence maximum of life in prison. That means something else. So obviously it means Parliament meant to treat this very seriously, and therefore the court should take that into account. So it's certainly not irrelevant that a sentence would have a maximum of life in prison. The charter statement also says that the term hatred should have a high threshold. So you're allowed to, say something bad about somebody. You can say something derisive and all these things. But if it reaches the high threshold of, inciting violence, or, getting to the point where there's a heavy risk that it'll incite violence, well, that's different. Yes, perhaps, but that is not going to solve what I think is one of the big problems, which is it's going to add to the burden of all of these cases. Every time, there's somebody that doesn't like the other person against whom they've committed the crime, which is not going to be seldom. That'll be a not uncommon factor or element of a crime. Then the investigation is going to have to then involve whether it was motivated by hatred, and so it adds time at the investigation level, it adds time at the trial level, it adds all these things. Even if at the end, it's not found to have met the high threshold, it still would have had an effect that led up to that point. The other part was the peace bonds for speech in advance. So, like I said, you can get a peace bond to prevent somebody from coming to see you or having any contact with you if you have a fear of violence. Well, this is where the Atlantic article talks about thought crime and pre-crime, which is this person might say something hateful. Okay, and so therefore they have legal restrictions placed on them. That's getting into sketchy territory there. So I don't think that the charter statement, which was quite vague, I will say, as I was reading through it, they identified different charter rights that might be impacted or might be relevant, but they didn't quite say how they would justify all these things. So not sure how that's going to hold up if the legislation passes when it is inevitably challenged in court. Okay, those are the national stories. Sorry, one more national story. Oh yes, the secret trial. So the Supreme Court of Canada said that the Court of Appeal in Quebec should not have characterized this thing as a secret trial. It was held in camera, so it was held without public access, so the open court principle was violated. You're supposed to be able to see what goes on in court. But what was going on was it was an informant, a police informant, that was charged with a crime. And we don't know much about the circumstances, but what the trial level judge found was that it was justifiable to have the entire proceedings take place in camera in order to protect the identity of the informant. Now, presumably, there was some balancing of the right for us to know what's going on, particularly with an informant, really, and, that they're not, unduly using their status as an informant to their own advantage in a criminal manner and these sorts of things. We don't know. I mean, we're speculating on what may have taken place here. So the trial took place, and the decision was all done in secret, but and so the Quebec Court of Appeal said this was improper. This was a secret trial. It shouldn't happen. Supreme Court of Canada says, don't call it a secret trial. It wasn't. It was just in camera where nobody could see it. So parsing things a little bit. But the Supreme Court of Canada did say that the trial judge should have had a more extensive record. Rather than just having everything secret and in camera, you should at least have at least a court number, there wasn't even a court number issued for the trial. So there was, no record of it if you were searching within the court records. And, you can redact the person's name and details that might tend to identify them, but you should publish something about it so that there is a record of it. So, interesting little thing, the Supreme Court said there is no such thing as a secret trial in Canada. Well, there kind of was there, and I guess they're saying there shouldn't be in the future, but really they were talking about that trial. Okay, let's move into Nova Scotia cases. And the news, I guess a news story this week, which was the Justice Minister Barbara Adams saying that 1,200 cases, an enormous number of cases, are at risk of being dismissed because of timelines, that they're getting outside the Jordan timelines of 18 months for provincial court trials, 30 months for Supreme Court trials. Brought to light by the stay of proceedings ordered in the Jeremy McKenzie situation where he was harassing Dr. Strang, protesting outside his home, and that was set to go to trial. It took too long, and so it was there was a stay issued, which means that the case is effectively over. Of course, startling in a sense that the public prosecution would not have put more effort and resources into making sure that Dr. Strang, in particular of all people, that such offenses are prosecuted. Not only because it's him, you can't give extra special treatment to anybody, but Dr. Strang might be a notable person to have make sure that the public understands this stuff. So conversely, because Dr. Strang is such a public individual, it draws a lot more attention to the fact that these delays are taking place. Now, the province has said, and rightly, that more prosecutors have been hired, and there's a budget for that. Heard Rick Woodburn, the Assistant Chief Prosecutor for the Public Prosecution Service on CBC the other morning, talking about what's going on here with these delays. And he said two things, really. The pandemic is one. Of course, the courts were shut down for months, and so there's a natural backlog just as a result of that, which everybody's still working through. But also that the cases are becoming more complex. And I've talked about this before too, particularly with sexual assault cases. The evidence pretrial applications are much more extensive than they were even 5 years ago, but certainly longer than 10 years. If you're looking 10 years, 15 years back, complexity of cases has increased dramatically, and so that takes a lot more effort from the prosecutors, from the judges, and everybody involved. Another thing that the province has done is introduce a bail court. So this is another thing that naturally delays things, right? So we have a trial scheduled for Monday, and you're all set to go, but people are arrested over the weekend and they need bail. Well, they go first because they're in jail. They might be in custody and they need to decide, somebody needs to decide whether they're going to be released. The Crown opposes release, then you have a bail hearing. You have a right to do that, in a very short period of time. The Crown can ask for 3 clear days of delay to prepare themselves for the hearing, but that naturally interrupts other trials that are scheduled, which need to be rescheduled, and you need to find time, and so on and so on. So in Halifax, they're going to introduce this bail court, and it's supposed to eliminate or at least reduce the number of other disruptions that are taking place because of that. Now, the other part is there's a full complement now of judges. There had been some issues with hiring judges. That's been taken care of, but there is still one judge on leave, and that leads me, I guess, into my next story, which is Judge Rickola Brinton. We've talked about her. I've talked about her a little bit, and because she was supposed to deliver a decision on Braden McNeil, that fairly serious sounding sexual assault charges against young boys, didn't deliver the decision. Turns out that she was put off the bench by the chief judge because she wouldn't get the COVID shot. She wouldn't, or declare that she was going to, or that became a whole thing between her and the chief judge, Pam Williams. She was placed on leave and has never come back. So that's one side of it. The other side now, that is Judge Brinton, had made a complaint, and that complaints about judges are heard by the Chief Justice of Nova Scotia, Michael Wood, Chief Justice of the Court of Appeal, and he dismissed the claim. So now Judge Brinton has applied for judicial review of that decision, and it goes in judicial review to the Supreme Court level, and it's going to be heard by Justice Krista Brothers. So an interesting and somewhat circular collection of judges here. So Judge Brinton complained about Judge Williams. The complaint was heard by Chief Justice Wood. That is going to be reviewed now by Justice Brothers, and then potentially then appealed from that level to the Court of Appeal, where it will be back before Justice Wood. Of course, Justice Wood would not sit on any panel in the Court of Appeal if it got to that level, but You can see how there's a lot of judges involved in these cases, and so far nobody seems to agree with Judge Brinton. So we'll see if Justice Brothers does, and where that might go from there. All right, a couple more cases to get to. One is just to quickly talk about this decision from Chief Judge of the Provincial Court, Perry Borden, on the impact of race and cultural assessments. These are becoming more common for African Nova Scotian accused. This guy, he goes by initials in the decision, CB, 18 years old, pled guilty to possession of a loaded handgun and 12 grams of cocaine found in his car. And he was represented by Patrick McEwen, a defense lawyer. Very good lawyer. Softball fans will know his father is longtime umpire John McEwen. Really good umpire. So the issue was, does this person, CB, he was eligible to go for federal time, 2+ years in jail, or a conditional sentence, a house arrest, basically. So Judge Borden went through the impact of race and cultural assessment report, which told him that CB had a loving mother, but a father who was either in jail, gone, or when he was around, he was living lavishly in a criminal manner. CB had a gun pointed at his head when he was 8 years old by an adversary of his father. Had his house raided when he was in high school in Ontario. His brother was being arrested. Heavy police presence, raided it. He lived right across from the high school where he was a star basketball player. And so that had a big impact on him. He had a close friend shot when he was moved back to Nova Scotia, and had done, in the time since he was charged, had done quite well. He was employed, no breaches of any conditions, and he and his girlfriend were expecting a child. So all of those things. Now, Judge Borden made a point of saying that there's nothing automatic about these reports that bring a reduced sentence, but in this case it was justified. He did sentence the young man to 2 years of house arrest with probation and conditions for counseling and such. All right, next one. Interesting decision from Justice Josh Arnold this week on the Preston by-election from last year. So the governing PCs picked up the seat for the first time ever. Liberal Party complained that the Chief Electoral Officer improperly ordered them to take down signs and open a police investigation, and announced that she'd opened up a police investigation. So the signs in question were regarding a landfill site, a dump, and said that the Houston Conservatives have done nothing to stop this dump. And so the Chief Electoral Officer said that violated the Elections Act, Section 307, because it was a statement about a, quote, candidate's character or conduct. Well, Justice Arnold said the material didn't name a candidate, didn't name Twyla Gross, the PC candidate. There was no reference to anybody's character or conduct. Seemed obvious from the plain reading of the sign. And that the Chief Electoral Officer should not have ordered the material removed, or should not have announced the police investigation. So cold comfort, I guess, at this point for the Liberal Party, but that should not have gone the way it did. It was improper, and so they get declaratory relief and a costs award against the Chief Electoral Officer. So interesting. Now we'll see. I'm sure now that'll obviously affect future conduct of the Chief Electoral Officer, but that seemed like a particularly bad decision on their part. Last case I want to talk about. This is interesting, right? These you see, if you drive around Nova Scotia, you're seeing these everywhere. Right after cannabis was legalized, of course, in Nova Scotia, it's only in the NSLCs where you can go get it, and it'll have the excise tax stamp on it, showing that it's a legitimate government cannabis. All right. So these places two in Millbrook, one in Cole Harbour, were raided. The Flower Barn, High Times Station, and Jason's Convenience. The accused are Matthew Cope, Darren Marshall, Alicia Brooks, and Jason Brooks. And no duty paid on the cannabis, no excise tax act stamps. So Judge Rhonda Vanderhook, the Associate Chief Judge of the Provincial Court, was asked to determine whether these pot shops, cannabis dispensaries, unlicensed, are protected by a constitutional right under Section 35 being a treaty right of the Mi'kmaq. Well, there were two expert reports provided by the defendants, the applicants, I guess, in terms of the constitutional element of it. And one was from a McGill law professor who said that the Mi'kmaq traded some hemp, perhaps, maybe, but didn't really provide any substantiation for cannabis usage or certainly trading. And what Judge Vanderhook correctly says is, and this is what the treaty cases all say, is that the right had to, or the practice had to be in existence pre-contact. And there's some leeway there if it's something similar to it, right? If you're fishing one kind of fish or growing something and doing something similar to it, but this growth and trading of cannabis was not something that was in existence, or nothing, at least that these experts were able to point to say that it was in existence pre-contact. There was no marijuana usage in those days, maybe hemp for like rope and other purposes. And so the constitutional questions were dismissed. Now the court did invite a better case if there's actually better evidence. I get the sense that maybe there wasn't a great deal of resources put into this case, but it's a big deal, right? Because you see these cannabis dispensaries everywhere you go when you go through a reserve or through communities. Where you can see them. You can see them from the highway going through Millbrook. You can see signs, around Buckenkeg and other places. So, what's going to happen? Well, the judge did not declare that all of those shops are now presumptively illegal, but that's really the implication of these. So it'll be interesting to see if now the police feel emboldened to start raiding some more of these shops, shutting them down. I'm sure many would argue that is probably not a bad thing. The proliferation of these shops in reserve communities seems like it can't be a great thing for just to have in the atmosphere of these communities for young people growing up there. But it's a bigger question that I'm going to address today. But that's that decision. So these particular shops, the raid against them, they've been found guilty of violations under the Excise Act, so they'll have major fines to pay. But there's been no declaratory order from the judge saying they have to shut down. So we'll see if that comes next, and we'll see if other owners are prepared to put more resources. If there's any evidence to be gathered out there that there was usage of cannabis pre-contact, then that could change things significantly. But that evidence has not been forthcoming as of yet. All right, so that's it for this week. So tomorrow night normally would be the Sunday night show, the Canadian Crime Weekly, as it's now called, with Jordan Bonaparte and Paul Palango, where I join in there. That's not going to happen this week. Paul is away and Jordan is unavailable as well, so we'll skip this week and see it again next week. And I'll be back as well with more stories next week, so I'll look forward to having you join then. So otherwise, tomorrow's Father's Day. Happy Father's Day to all the fathers out there, including mine. And I hope everybody has a great day. Hope the weather's nice and you can get outside and enjoy some time with your dad. All right. So until then, thank you everybody for watching. Thank you everybody listening, and we'll see you next time.